Thank you for being here. This panel, entitled The Executive Branch's Duty to Enforce, is sponsored by the Litigation Practice Group. Our moderator for this panel is Judge Greg Katsas, who serves on the United States Court of Appeals for the District of Columbia Circuit. Prior to his service on the court, Judge Katsas held many senior positions in federal government, including Deputy Assistant and Deputy Counsel to the President, Assistant Attorney General for the Civil Division, and Acting Associate Attorney General. He was also a partner at Jones Day in Washington, D.C., and served as a law clerk to Judge Becker on the Third Circuit, and to then Judge Clarence Thomas on the D.C. Circuit, and then to Justice Thomas on the Supreme Court. Judge Katsas?
Thank you. So our topic is executive branch duty to enforce federal law, or equivalently, the executive's discretion not to enforce federal law. It's a big topic. Panelists are going to touch on at least three different aspects of this question. One is the very familiar issue of prosecutorial discretion, which arises anytime the executive decides not to bring some kind of adjudicatory enforcement proceeding that would be legally justified. This has been a topic of major debate in the immigration area. Right at one end of the spectrum, everyone agrees that the government doesn't have to try to remove any individual alien that could be removed, just as the government doesn't have to pursue every criminal case it could pursue. At the other end of the spectrum, if the government were to simply announce that they are not going to enforce any immigration law under any circumstance, that would obviously be lawless. So what, if any, are the principled lines that can separate one extreme from the other? Is there any guidance we can draw from the Constitution itself, which simply requires the executive to take care that the laws are faithfully executed? What can we draw from Heckler versus Cheney, which is the leading Supreme Court opinion saying that exercises of enforcement discretion are presumptively unreviewable, at least under the APA? And whatever lines there are, how do they apply to initiatives like the DACA program, which establishes criteria for non-enforcement in advance and covers a large number of aliens and links the non-enforcement decision to the provision of various benefits. Second thing we're going to talk about is the executive's duty to defend the constitutionality of federal statutes when they're challenged in court. When I served at DOJ in the Bush 43 administration, there was a pretty long-standing and widespread and bipartisan consensus that the executive has a duty to defend the constitutionality of federal statutes, regardless of how much the executive likes or dislikes the statutes, with two narrow exceptions. One, if no reasonable argument could be made in defense, or two, if the statute trammels on executive authority, in which case the theory was DOJ's primary responsibility is to the president over Congress in the event of a conflict. That consensus has maybe been frayed a little bit over the last couple of administrations, with the Obama administration's refusal to defend the Defense of Marriage Act and the Trump administration's refusal to defend the Affordable Care Act in the last round of Supreme Court litigation. At the same time, the executive enthusiasm for defending statutes has arguably waned in some high-profile cases. States have shown an increasing willingness and eagerness both to challenge and defend federal statutes and federal regulations. And under the special solicitude of Massachusetts versus EPA, have been given perhaps greater standing in order to come into cases and do that. So we've seen this weird situation now where, take the last iteration of the Affordable Care Act litigation, you would think the configuration would be the regulated party versus the federal government, which is what we had in 2012, but it's sort of morphed into California versus Texas. California standing in for the federal government to defend the statute, and Texas trying unsuccessfully to stand in for the challengers, and query whether if every major challenge to an edgy statute or regulation is going to turn into California versus Texas or Texas versus California, depending on whose ox is being gored, does that make it less essential for DOJ to itself defend on the theory that Congress itself needs to have its own interests represented? The last topic we're going to touch upon is agency authority over ambiguous statutes and regs under Chevron and Kaiser. This is not traditionally thought of as an issue of enforcement discretion, but think of what happens under these deference doctrines when an ambiguous statute has at least two reasonable interpretations. Court doesn't roll up its sleeves and look at text structure, canons, and history and figure out what the best reading of the statute is in a 5149 case. The agency gets to decide, and gets to decide based on its discretionary policy judgments. So what happens when there are two reasonable answers? One illustration of this close to home for me is the debate in recent years over net neutrality. It turns out that question turns on this wonky legal question about whether broadband internet service is a telecommunications service under the Communications Act. And the DC Circuit has said it is reasonable to answer that question yes, and it is reasonable to answer that question no. So guess what happens? The FCC goes back and forth depending on how the makeup of the commission. They said no in 2002, they said yes in 2015, they said no in 2018, and one suspects they may not be done. Are there any principled limits on the circumstances in which the executive should turn ambiguous statutes on and off as administrations change? We've got a great panel to talk about these issues, so let me just introduce our speakers without further ado. Justin Savage leads the environmental and automotive practices at Sidley Austin. He counsels clients in heavily regulated industries such as energy, chemicals, and mining. His expertise extends across the spectrum of environmental, transportation, and administrative laws, including the Clean Air Act, Clean Water Act, CERCLA, NEPA, the APA, FOIA, and various statutes administered by NHTSA. Justin served for nearly a decade in the Environment and Natural Resources Division at the Department of Justice, where he led teams in several multi-billion-dollar enforcement cases. He's frequently taught environmental law, including for DOJ and the American Law Institute. Steve Bradbury served as general counsel of the Department of Transportation from 2017 to 2021. He also served as the acting deputy secretary of transportation and briefly as the acting secretary of transportation. From 2005 to 2009, Steve served as the acting assistant attorney general and the principal deputy assistant attorney general for the Office of Legal Counsel at DOJ. As head of OLC, he advised the president, the attorney general, and the entire executive branch on a wide range of issues. He was also a litigation partner at Kirkland Ellis and at Deckert, and he clerked for Judge James Buckley on the DC Circuit and Justice Clarence Thomas on the Supreme Court. Sean Donahue focuses his practice on appeals in environmental cases. He represents public interest, governmental and private entities in clean energy, natural resource, and other environmental cases. For 4 years, he served as an appellate attorney at ENRD. He formerly practiced at Jenner & Block, and he now runs his own firm. He's argued some 50 appeals. He's taught courses in environmental law, civil procedure, and constitutional law at Washington and Lee, Iowa, and Georgetown University law schools. He currently teaches climate change, law, and policy at Stanford Law School. Sean began his career as a law clerk to Judge Ruth Bader Ginsburg on the DC Circuit and to Justice John Paul Stevens on the Supreme Court. And finally, Ryan Newman is the general counsel to Florida Governor Ron DeSantis. During the Trump administration, he served as counselor to the AG, as deputy general counsel at the Department of Defense, and as acting assistant attorney general for the Office of Legal Policy. He's also served as chief counsel to Senator Ted Cruz. Ryan clerked for Justice Samuel Alito on the U.S. Supreme Court, for Judge J.L. Edmondson on the 11th Circuit, and for Judge Richard Leon on the district court here in the district. Before becoming a lawyer, Ryan was an armor officer in the U.S. Army, and he deployed to Iraq to participate in Operation Iraqi Freedom. Thanks for your service, Ryan. Justin, the floor is yours for whatever opening you'd like to give us.
Thanks, Judge, and thanks, Steve, Sean, and Ryan for joining this, what hopefully will be an interesting discussion. So I'm going to start this morning by boring you. I'm going to argue for the traditional approach of substantial discretion, particularly enforcement discretion under Heckler versus Cheney. I know there's some hipster theories, some cool theories, and I have kids in their 20s and they say I'm old and boring, but sometimes old and boring is good, and tradition is good because it's not fragile, it's past the test of time. So cast your mind back to the 1980s, where there was a much different DC circuit, and a panel on that circuit in Heckler versus Cheney decided that it would be a good idea to force the FDA to regulate drugs given to people on death row. Does anyone think that makes sense? I don't. So what happened is the U.S. Supreme Court decided that unless there are clear textual and other statutory signals, the executive enjoys nearly unreviewable presumptive discretion to enforce. As both a legal and policy matter, that makes sense to me, as someone who both enforced the law for 10 years and now defends companies and individuals, it makes sense. The executive is elected, judges are not. Line prosecutors in the Justice Department, where several people on this stage served, as best able to make the decisions on when, how to enforce dockets, resources. To me, it's incredibly dangerous that an insular, no offense, Judge, branch of government that's not elected would be making these calls. Yes, there are difficult lines to draw, but the line should always lean and draw toward more deference, not less. And, would someone say, well, this could allow the Biden administration to get to wreak incredible outrages upon the country? I will say there are elections coming up. They're coming up this year. They're coming up in 24. And then cast your mind back to the last administration where several people in this room serve. I can see someone I know over there. Think about what happened just with EPA, and we have a few environmental lawyers on the stage. Their typical win rate is about 80%. In the last administration, it wasn't. And I don't want to call out particular judges or decisions, but I think there were some incredibly invasive decisions in environmental law that disrupted what the last administration wanted to do. So in closing, all I'll say is Heckler versus Cheney, to me, should remain our North Star. We should be committed, unless there are clear textual signals in the text of a statute, to unreviewable enforcement discretion. Thank you, Judge. And now I'll pass it on to Steve.
Thanks. Is this on? Yes? Great. Thanks, Justin. I'm going to focus on the regulatory front, the obligation of administrative agencies, executive agencies to implement a statutory program that Congress has enacted. And I want to focus on one word in the Constitution. The word is faithfully. The executive has an obligation to carry out the law faithfully. And I take that to mean that the executive agency, the officers of the executive branch who are implementing a statutory program, have an obligation to implement it in a way that's consistent not only with the literal terms, words and phrases of a particular part of a statute, but also with the structure of the statute and with the context and purposes that inform its enactment by Congress. Certainly when it comes to judicial review of those agency actions, as Justin was describing, there's a role for deference. We don't want Judge Skelly Wright to substitute his personal preference for the right policy for the judgment of an agency. And there may be areas where the agency in carrying out the enactment has to look at the science, has to look at the economics of an industry, has to get up to speed and get expert in those important aspects. And we don't want courts who are generalists and who are unelected and unaccountable to substitute their judgment. So we have deference doctrines like Chevron. And Sean, clerk for Justice Stevens, I'll offer my observation that I think Chevron is probably the most influential opinion that Justice Stevens ever authored, in my view. It makes sense, it's understandable. The problem is that what you see is executive agencies rely on Chevron and other doctrines of deference as covers or devices that they exploit to allow them to push the bounds of what Congress intended in a statute, what the statute really authorizes them to do. And so you see swings, radical swings, in policy from one administration to another, and they hang their hat on the fact that the courts are going to give them deference. And so, you know, come and get us. We think we can get away with it, basically. One example that's close to home for me from the Department of Transportation and also in the EPA context is fuel economy regulation. Congress originally passed the Energy Policy and Conservation Act in 1975 to regulate fuel economy of new motor vehicles. And this was passed in response to the oil crisis of 1973 caused by the Arab oil embargo. And it was an effort Congress envisioned to give a nudge to the automotive industry to be a little more innovative, try to improve fuel economy so that our nation strategically and as a matter of national security would be less dependent on foreign oil. It gave this charge, this mandate, to the Department of Transportation in 1975. It did not give it to the Environmental Protection Agency. This is not an environmental statute. This is a transportation policy statute. They gave it to DOT. They could have given it to EPA if it was environmental. EPA had the Clean Air Act. That was enacted 5 years earlier in 1970. And EPA had, in Title II of the Clean Air Act, authority to set emission limits for new motor vehicles. The objective there was to try to clean our cities of smog. That was a real problem. But Congress didn't give the fuel economy mandate to the EPA. It gave it to DOT, the Secretary of Transportation. It's implemented through NHTSA. And in that mandate, NHTSA has to take into account technical feasibility, economic practicability, the need of the nation to conserve energy, really meaning at the time oil from foreign sources. And this allows NHTSA to take into account things like what is really today technologically feasible and what will consumers buy, what's economically practicable, what kind of vehicles can the automakers actually sell in the market. Congress did not want to disrupt the industry. They didn't want to make the industry go bankrupt. And they didn't want to deny consumers and the American people the great benefits to liberty and to the economy that automotive mobility gives. So it was a very carefully crafted statute, and Congress was very intent that these mileage requirements for automotive, for new cars, gradually increase and don't go overboard. Okay, and there are a lot of indications of that, which I can go into in detail, but come the 2010s, in the Obama administration, they had a focus on climate change and trying to suppress carbon dioxide emissions. Carbon dioxide emissions don't cause smog. They cause this much broader concern of global warming, the EPA concluded. So They decided to use the fuel economy standards as another lever to try to force the industry, basically to transform the whole industry to move toward electric vehicles. And they let the Environmental Protection Agency take the lead in that, and NHTSA kind of followed along, and they set standards that were dramatically increased in terms of miles per gallon requirements. The Trump administration came in. We tried to do a reset to make it more of a gradual increase, still pressing the bounds of what's technologically possible, but not at such a steep curve. Now you see in the Biden administration, they repealed what we did and they flipped back, and you have huge increases in mile per gallon requirements, 8% per year, and then in 2026, model year 2026, 10%, a leap up. And again, EPA is taking the lead on this. The clear purpose is to force the automotive industry to transform itself into electric vehicles, and there won't be any more internal combustion engine passenger vehicles that are made in the U.S. or sold in the U.S. Pretty soon, kind of consistent with the California vision. So very quickly, how do we bring this back into check? I think Congress is just an observer here, sitting back. I mean, Congress never addressed through statute how do we deal with climate change and carbon dioxide emissions through regulation of mileage and new automobiles. They never have addressed that at all. So we have this huge new regime created by these agencies. So I think we have to rethink judicial review. Under Chevron, think about putting more robust content into prong one of Chevron. Don't just look at whether the particular word is ambiguous or compels one and only one interpretation. Look at the whole structure, the context, the purpose of the statute. We see this in Judge Mizell's ruling on the mask mandate in Florida, where she looked at a particular word that the agency hung its hat on and said, yes, it is ambiguous, it has multiple meanings, but looking at the whole statute, we think Congress intended the narrow meaning. The other doctrine is the major questions doctrine, really an elaboration or modification of Chevron, I think. And you see this in recent Supreme Court decisions where basically if an agency has, by rule or otherwise, engaged in something that can be described as a transformational extension of the agency's regulatory mandate, then the court is going to insist not just that there be a reasonable interpretation of ambiguous terms, but that there be a clear and unmistakable mandate in the statute itself authorizing that extension. I think that's the right way to go. It has a lot of development to happen in the courts, but I'm very encouraged by that. Thank you. And I'll turn it over to Sean.
Thank you, Steve, and thanks for having me here today. And I guess I'd say, I think my role perhaps is to be, to kind of present a different view on some of these issues, although I basically all the general principles that have been expressed so far, I basically agree with. It was when Steve started talking about a concrete case that I work on the other side that I can't follow. I'm not going to talk about the EPA greenhouse gas emission standards. I will note, because it's a matter of public record, that the auto industry is supporting what EPA has done. So to the extent there's a question of feasibility, just note that. But I generally agree with the sort of view about how courts should read statutes in a way that is not focused myopically on particular words. They should read the words in context and look at structure and purpose, et cetera. I guess I just want to ask, and this is a kind of a, for those of us who are involved or have been involved as law clerks, as judges, whatever, this today is a kind of bracing day, another day that reminds us that a lot of norms are kind of shredding or seem to be no longer binding. And I think in administrative law, that's true. We're in a time of hyper-polarization and a lot of distrust. And I think that plays out in a lot of different ways in administrative law. When you have transitions from one party to the other, there's no longer a sense that there's new people in town and let's help them, kind of take existing policies and decide what needs to be tweaked and what needs to be maintained. There's a sense that like everything that the last administration did is anathema and it needs to be taken off the books immediately. And that leads to problems. That leads to probably suboptimal policy and also mistakes that I would say recommend Michael Lewis's book, The Fifth Risk, about the Trump administration's transition period, particularly with regard to public health. But it's certainly not unique to any particular administration. And I would say on the mask mandate case, I don't agree about the interpretation of the statute. I'm focused on the case very closely. But I do agree that dispensing with notice and comment on a rule as important as that, is sort of emblematic of the kinds of problems that you see with a new administration that's really eager to do. And if you think there's an emergency for public health, there are steps you can take to put a rule in and then hold comment, but not having notice and comment at all is an emblem of a kind of problem that we see in a time of sort of frenzied efforts to reverse or alter policy. I think so. My perspective on the obligation to enforce the law is I agree with all the sort of general comments. I think the executive has to have some discretion. It depends, of course, on what the statute says. I would note that in the area I work in most, sort of Clean Air Act, the statute is filled with obligations that Congress chose because it wanted to affect certain public health and other goals that require the agency to act. And those are the law too. And there are those of us who might want to change them, make them stronger, get rid of them, but they're the law just as much as the limits. And that's a point I like to make quite a bit in my practice. I'll say something about major questions because it's a very hot topic. But I think, when you look at often when we see descriptions of what the doctrine is, it's a bunch of cases, Brown and Williamson, this can the FDA regulate tobacco as a drug, the MCI versus AT&T case, and a bunch of others. And I think at one level, the principle that an agency shouldn't be able to find an elephant in a mouse hole or take a very small grant of authority and do something sweeping with it is completely commonsensical. We would all, and I would submit, I've not had the energy to do this, but that you could look back much further than the earliest cases and find courts interpreting statutes doing this all the time. We're reading the statute. This doesn't seem to be a big thing that you can do a lot with. It seems like a small thing, so it's not a permissible or reasonable or lawful interpretation. I think that's totally fine. I have no objection. I would say that there's probably a sort of corresponding principle the other way, that if Congress has given the agency a big authority or big obligation and the agency is trying to deny it or not use it, I think that's an error too. Maybe some sort of Congress doesn't construct elephant pens to house mice. All of that I find unobjectionable, and that's like the anodyne, benign version of major questions. I think there's another way in which the phrase is used, and that is, this is a warrant for us to achieve massive deregulation that we think is great policy. And I see those kinds of uses of it in briefs and arguments, and I, of course, disagree with that. I think you should, you need to change the law if the law doesn't currently support, and so I think, major questions has a limited role to play in statutory construction. And I guess, I'll just, I think we live in sort of, and I've been practicing now for more years than I want to think of, 30 years. I think we live in a sort of a singularly fraught time where we really need to think about the rule of law and the services it provides us in a democratic republic. And when we recently had people trying to overturn the results of an election through violence. And we still have people denying the clear and fully adjudicated results of a national election. I think we need to repudiate that, and we need to focus on our disputes on using the law and its processes to achieve change in a peaceful and regular way, and that precisely because we're so divided, we really need to call upon the services that law and the legal process provides us for resolving our disputes peacefully and in accord with the way our country was conceived. And with that light note, I will turn things over to Ryan.
Thanks, Sean. Well, it's great to be back. I think it's great to be back in D.C. Well, I think one of the great challenges is trying to figure out, how do you make the government follow the law, right? I mean, that's what the framers were trying to, what was it, Madison said, the first task is to, the government's got to control the people, but then how does the government control itself? How do we make the government follow the laws that it enacts? Well, the separation of powers and the system of checks and balances often work remarkably well at preventing unauthorized action by the federal government. And that's a good thing, right? I mean, that preserves liberty. We don't want the government to overstep its bounds. But what about unauthorized inaction by the government? What about when the government refuses to do what it is legally obligated to do? Is the constitutional framework capable of ensuring that the federal government actually carries out the laws that it enacts? I'm a little concerned that perhaps not. If Republican government means anything, surely it means that the government must execute the laws enacted by the people's representatives. I find it interesting that the very first charge leveled against King George III in the Declaration of Independence was that he, quote, refused his assent to laws, the most wholesome and necessary for the public good. There's no question that the king trampled on individual liberties. But it's noteworthy that the first objection that our forebears raised was that the king would not let them govern themselves. It's not too great a leap, then, to posit that when the president refuses to take care that the laws be faithfully executed, he too is denying the people their right of self-government. Sure, the president may veto a bill subject to override, but once a law is duly enacted, he must take care that it be faithfully executed. In putting down the Whiskey Rebellion, our first president did not retreat from this duty. He said, "It is my duty to see the laws executed. To permit them to be trampled upon with impunity would be repugnant to that duty." Now contrast that with the response of our 46th president to the trampling of our immigration laws at the southwest border. Does anyone really believe that this administration is faithfully enforcing the immigration laws enacted by Congress? I mean, to ask the question answers it, right? We all know, of course not. Virtually every action that this administration has taken has undermined, has made it more difficult to ensure that the immigration laws are actually carried out and brought to bear. Now, as it turns out, I don't disagree with the principle that the executive branch is entitled to a great deal of enforcement discretion, and that generally such discretion is not reviewable by courts. But I do think the lawlessness at the border is the exception that proves the rule. Even the Supreme Court acknowledged in Heckler versus Cheney that agencies cannot be allowed to, quote, consciously and expressly adopt a general policy that is so extreme as to amount to an abdication of its statutory responsibilities. That is precisely what the Biden administration has done. Its goal is not to reduce the amount of illegal immigration at the border, to enforce the immigration laws of this country. Its goal is to facilitate illegal immigration at the border. And don't take my word for it. DHS Secretary Mayorkas confirmed as much just this weekend, when in response to the question, is it the objective of the Biden administration to reduce the number of illegal immigrants coming across the southern border, he answered, it is the objective of the Biden administration to make sure that we have safe, legal, and orderly pathways for individuals to be able to access our legal system. That's another way of saying no. So the question is, what is to be done when the executive branch refuses to faithfully enforce the law? Now, Justin says, hey, Justin, there you are, that the only remedy is the next election.
Yep.
But doesn't this make a mockery of the past elections that produced the laws that the executive branch is supposed to be enforcing? Why must the people keep voting to enforce the laws that they have already voted for? Non-enforcement of the law, and I'm not talking about individualized exercises of enforcement discretion. I'm talking about general policies promulgated by agencies that are calculated and designed to prevent the carrying out of the laws. That defeats the will of the people, and the courts have some role to play, just like they would set aside any agency action that exceeds the authority of the government. They should be willing also to set aside general agency policies that are designed not to force and carry out the law. And I think that, in limited circumstances, and I'm far be it from me to invite the federal judiciary to involve itself in more issues, but in those extreme circumstances, and immigration is obviously one of them, the courts do have a role to play.
Thank you. We are right on schedule, so I'm going to offer each panelist a couple of minutes to respond to your colleagues. Justin.
Thanks, Judge. And I'll just say we need to take a step back in a bigger picture. Yes, we're polarized, but remember in 1856, Preston Brooks went to the floor of the Senate and caned Senator Charles Sumner, right? We have been polarized before, and right now in this world, there are countries that lock people in their apartments because of COVID, or invade other countries and try to destroy them as a society. So yes, we disagree on things. Yes, we should always be vigilant for freedom. But no, I don't think we're at a historic low or we're in danger, because it's the greatest country in the world that gives us opportunities. It gives us clean air and clean water. I have to travel a lot for work. We should be thankful for that. So it's really just a question of degree and modicum and where you draw the line on that. On that, my friend Ryan, I thought it was a stirring speech. I was ready to get up here and vote. I didn't hear a lot of textual clues, and we may not like, or folks in this room may not like, less immigration enforcement. But I'll tell you what, if in 2024 Ryan's old boss comes back, or there's another Republican, or maybe his current boss, takes that White House, you really want Sean suing them for more environmental enforcement, more health and safety enforcement, more Department of Education? So to me, I didn't hear any textual clues that would guide how courts, with all due respect to the judge next to me, force the executive to enforce the law. Thanks.
Steve.
Well, I guess Sean is recused, but he dropped a little nugget there. He said that, oh, by the way, the auto industry, they support these sky-high mile-per-gallon standards that they're going to have a great deal of difficulty building to. I mean, I think General Motors sold a grand total of 527 all-electric vehicles in the first quarter of this year. Elon Musk had a happy little tweet where he said, Tesla sold, 310,000 units in the first quarter. General Motors, 427 or 527, something like that. And yet, they're going to have to build pretty much all electric fleets, or mostly, and then pay their penalties for their Camaros and their Corvettes, which can't meet the standards, and then, of course, raise the prices of those and their pickups and everything else. Prices are going to go up, and of course, consumers won't be able to buy as many units of those new vehicles, and so they're going to depend on used vehicles. We're going to have a fleet. Right now, our fleet is 11 or 12 years old on average on the streets of the U.S. It's going to go up to 20 years, 25 years. I mean, it'll be like a little bit more like Cuba. Everybody's going to be driving around in, there'll be the fifth or sixth owner of a used vehicle, which is not as safe and not as fuel efficient, et cetera. I think this phenomenon of the industry kind of getting in league with the regulator to go along with these impractical efforts to transform an industry and extend the agency's authority is an example of how entrenched business concerns in an industry actually sometimes embrace draconian regulation. Among other things, it keeps the new entrants out. It just imposes higher costs, which if you're part of a small number of big operators in an industry, you can usually pass along to consumers. And that's, we heard about it on an earlier panel today in the ballroom on the investment advisors, like Larry Fink at BlackRock and others, sort of forcing these companies to go along with these policies that transform whole industries and areas of the law, and the biggest companies are going along with it. That doesn't mean there isn't someone with standing, maybe representing union workers who are not going to benefit from electric vehicles because they're assembled by far fewer workers than internal combustion engine vehicles, or consumers who are very much harmed by this regulatory overreach to try to transform an industry, who have standing to get into the courts. And again, the key is, I think, if Congress isn't going to take this on directly, is the courts getting more responsible in terms of ensuring that these statutory programs stay within the field envisioned by Congress. Thanks.
Sean?
Okay, well, I mean, I think quite apart from regulation, the auto industry pretty much across the board and around the world, it is going in this direction very fast. So I'm not an expert in what's feasible, but I would defer to the companies about where they think the market is and what they think they can do. And then on the law, we'll see, and that'll be hashed out. I think when Ryan was talking, I think I have a fundamentally different view of the immigration issue. I'm sure I do. But everything he said, I mean, if the executive branch adopts a policy of not enforcing something that is a statutory obligation, then I think a party with standing normally ought to be able to challenge that. And it all depends on what the statute says, and my very, very imperfect understanding of these disputes is a lot of it is kind of everybody agrees that it's impossible to fully enforce, and it's a question of how much sort of triage is permissible, required, et cetera. But the general principle, Justin, it sounded to me like was maybe going toward a pretty extreme view of executive discretion, where an agency really could say, you know what, Congress told us to do this thing, we're not really crazy about it, and maybe next election you can but elections, there are a lot of different issues people vote on, and a statutory, maybe immigration is an issue that's big enough that voters will, but that sort of idea depends on the premise that this is actually going to be outcome determinative. Maybe it's not that important a statute to most people, never going to affect an election, but it seems to me that could sanction just kind of executive undoing of a statute, and that seems to me procedurally problematic or constitutionally problematic. So I'll stop there. And, turn it
Ryan.
to you.
Well, thanks, Sean. I really feel like I have an ally. No, I mean it's true. I mean a lot of the the devil's in the details. What makes immigration? I don't want to sort of get into the details of immigration law because it will lead to the weeping and gnashing of teeth. But one thing's for certain though about immigration laws, Congress is pretty clear when it wanted the executive to have discretion on certain things, and so. It was also clear when it didn't really want the executive branch to have, a whole lot of discretion thing. I mean, that doesn't sort of resolve the fundamental problem that Sean was sort of touching on, which is the triage problem, that at some level the system is overwhelmed and, the executive branch simply cannot, even in good faith, completely comply with the law. That's certainly true with FOIA. I mean, right? The Congress sets all kinds of sort of statutory deadlines that get blown off. But if somebody brings a lawsuit, right, the courts don't just say, can't do anything here. They recognize, they will acknowledge the resource challenges the executive branch has, but the courts will still oversee and make sure that the federal government is in fact faithfully carrying out the law. And so I guess all I'm asking is that the courts not be so quick in the immigration context to just throw their hands up and say, this is just enforcement discretion. Because what the executive branch is doing right now in a number of areas is particularly appalling. Now, immigration laws make very clear that the executive branch shall take into custody certain categories of criminal aliens. Okay, and so today there are criminal aliens who are being released from Florida prisons that would have been taken into custody by the federal government that are not being taken into custody today. Why? There's no good reason for it. And the executive branch hasn't been able to offer any good reasons for it. The laws are very clear that someone seeking admission who is not entitled to admission to this country must be detained pending their removal proceedings. There's the limited exception that a person can be paroled, but it's very cabinet. It must be, the decision must be made on a case-by-case basis, and it has to be for urgent humanitarian reasons or significant public benefit. And I get that the numbers now, in which I'll just point out that is a problem of the executive branch's own making, make it very difficult, obviously, for the executive branch to detain everyone. But that's why Congress also provided the authority to allow the executive branch to have applicants for admission wait in Mexico pending the resolution of their removal proceedings. And yet that authority, which Congress has given to the executive branch to help it meet its statutory obligations, just terminated it. Terminated the authority, refuses to exercise the authority that Congress has given it in order for the executive branch to meet its statutory obligation. That can only be seen as a faithless attempt to not enforce the immigration laws of this country. And it's, in my mind, it's just absolutely appalling. And it's really problematic, and I just want to make one other point, shout out for the states, because the states have been rendered effectively powerless to defend their own interests in our system of government. The Supreme Court has effectively, Arizona versus the United States, said that, the states can't, enforce or create, state enforcement of, federal immigration law. So they can't exercise self-help, so in the context of drug laws, for instance, I mean, the federal government refuses to enforce a lot of its drug laws, but at least the states have the benefit of self-help. They can enact their own drug laws and enforce them. Not the case, though, with immigration. The states are virtually powerless to do anything about it and are completely at the mercy of the federal government. And so I think that just further underscores the need to have the judiciary play at least some role in ensuring that the executive branch is actually faithfully carrying out the laws that the people's representatives have enacted. Otherwise, we're not really a republic anymore, and we're certainly not a republic of laws.
Let me just ask one or two questions, and then we have plenty of time for questions from the audience. So Justin, you said enforcement discretion prevails unless the statute has some textual clues of a mandatory duty. So I know you're not an immigration lawyer. I won't hold you to this, but let me just describe in general terms a recent Sixth Circuit opinion that I found very interesting. It's by Judge Sutton, who's a very careful and sober, excellent judge. He was dealing with one of the nooks and crannies of immigration law. I'm not sure if this is the provision you had in mind, Ryan, but one of the nooks and crannies of immigration law where there was a mandatory obligation shall take into custody certain categories of illegal aliens. And Jeff said, well, you know, shall means shall, but we need to look at things more broadly. The immigration code is tremendously complicated. There's a very strong background interpretive presumption of enforcement discretion. And number three, you have to consider not only the substantive law, but the resources that Congress has provided, and even focused on this limited category of shall, the resources provided are off by an order of magnitude, and putting all of that together, shall really means may, or it doesn't fully mean shall. Does that sort of go too far, or what's your reaction to a case like that?
I mean, that seems right. Look, I have my own strongly held personal views on immigration. I come from a long line of police officers and sheriffs, believe in the rule of law, but as a legal matter, that seems right to me. There is an opinion in your own circuit. I don't know if Sean argued it.
The Sutton shall is may.
Yes, there's
an
environmental equivalent under what's called the Prevention of Significant Deterioration, or PSD program of the Clean Air Act, where I don't know if it was Sean's group, but groups came in and it says, I think it was in the Bush II administration, there's no enforcement of this. It says shall. Section 167, and I forget who wrote the opinion, maybe Centel, said it does say shall, but look at the statute as a whole, look at the rest of it, and we're not going to force EPA to do this. And having dealt with regulators all the time, having had them as clients, it is a reality that there are some environmental laws that don't go enforced in some administrations, and others are more enforced. Similarly with immigration, as a background fact, there are 11 million undocumented illegal immigrants in this country. It's a background fact. And there always will be a debate over will there be more or less. So to me, Judge Sutton's opinion seems to strike the right balance, because yes, it is imperfect. Yes, do I have my own views on this? But the remedy or the legal standard that you create, you can't say just because we want less immigration, I'm creating a legal standard of that. It has to apply across the board. And to me, there's a lot of danger of that. And if you look at what the Dem AGs or the blue AGs did in the last Trump administration, it was incredibly disruptive. And no one could say that President Trump hid what he was going to do. I mean, he was pretty clear. And I think similarly, I don't think President Biden made any secret of his view of immigration.
Ryan, I don't recall if Florida was in that Sixth Circuit case, but I'm guessing you have a different view. So.
Yeah, we're not in the Sixth Circuit case. So we had our own case that got mooted out when as oftentimes happens, the executive branch decides wants to change its policies. But yeah, no, my thought is that you do have to look at the statute as a whole. So I agree that just because the statute says shall doesn't, and Castle Rock makes that clear, right? But that's why, you know, you have to be a little discerning and read everything in sort of context. And when it comes to the immigration laws, there are mays. There are mays and there are shalls, which certainly indicate that the shalls have to mean something. They can't just mean may. And so I think in that respect, you know, Judge Sutton is a little off base in that. The other thing too I want to point out is that, yeah, I mean, I'm talking, you know, I don't have a problem with enforcement discretion on an individualized basis. The problem that we have with what the Biden administration is doing is that they're promulgating systemic policies, right? And so it's in the wheelhouse, of course, to say, no, that for either for APA reasons or other reasons, if it's, you know, contrary to law, to set those policies aside. The executive branch is always able to triage. It triages all the time. But when systemic policies are being created under the guise of triage, when the reality is that they're aimed at not faithfully carrying out the laws, courts ought to be, you know, at least skeptical enough to look into it.
Let me press you a little bit on what the line is, right? Heckler says enforcement discretion, unreviewable, unless it gets really bad. Is it the breadth? I mean, it can't be just setting a category in advance. You could imagine someone setting a very narrow, instead of 700,000, it's 700, and it makes perfect sense in terms of prioritizing. So is it a pretext? Some of your comments hinted at pretext.
Kind of. I think it is hard to draw, obviously, a clear line. That's why courts, you know, have struggled with this for a long time. But look, there wasn't a Trump administration that was promulgated that didn't get scrutiny, right? And so, you know, courts should apply scrutiny to, you know, to see if what the executive branch is saying about its policy really squares up. And, you know, obviously courts are going to have to exercise some deference in certain circumstances, obviously, but perhaps a little less so when statutes say shall instead of may.
Any other thoughts from the other panelists before we open it up?
Well, I'm sorry, Sean.
No,
I'll jump in and say two things. One, the 11 million figure is a very old number. That's many years old. It's gone up 2 or 3 million just in the last year and a half. On this,
I'm not going to tell you my source on that one.
on this point, I think that the question has to be, at what point does the exercise of a categorical prosecutorial discretion purportedly frustrate the statutory scheme? Basically, at what point is it a dereliction of duty so that you're really not carrying forward the statutory program or mandate that Congress intended? And that I think is requires a more all-encompassing consideration of the statutory scheme, the purposes, the context, etc.
Okay, let's.
Yeah, I was just going to note, you know, obviously, and this comes up in other areas, including environmental, the role of appropriations. Congress may have said shall about something, but may not have given the agency the resources to do it, and what role does that play, and how much should courts think about it as a lot difficult question sometimes.
Let's take some questions, please.
The Endangered Species Act, right? My question is about remedy. I think everyone agrees, well, there's some place in between here where optimal enforcement exists, and then the question is how do you get that? And one of the ways Congress has tried to force more enforcement is in the environmental context through citizen suits. So if this is in the legislative history, at least in the Clean Water Act and Clean Air Act, saying we think that there's a danger that the executive won't take enough steps to enforce these laws, so we're going to create this alternative enforcement mechanism where if the executive fails or decides to not enforce something, that we're going to go ahead and let ordinary citizens step into the shoes of the government as enforcers. It seems in tension with, to create some tension with this idea of sort of inherent discretion with enforcement. I'm curious for the panel's thoughts on this particular kind of remedy, or whether there's some other remedy that's, you know, not just some judge saying, like in a FOIA suit, you need to do this particularly here, but in a kind of more global sense.
Citizen suits, right up your
Yeah, I
alley.
mean, I would say if Congress has enacted a citizen suit remedy, that, you know, there are probably some prerequisites for proper citizen suit, but that's kind of a pretty clear statement from Congress that it doesn't want the executive to have unreviewable, dispositive discretion to not enforce.
Anybody else?
I mean, I'll just say we've had key TAM laws in this country since the founding, and I think courts have analogized citizen suits to those. And most in the environmental context, I think this is right, Sean. You have to notify the executive before you proceed with your claim, so there is some deference paid. But I mean, it's an interesting legal question, and one I know Michael has personal experience with.
Next question.
Morning. This is a really interesting conversation, I think enriching for everyone who's here. My background's in administrative law and federal courts, and my question, I think, focuses on the triangulation of three specific points that is germane to this subject. First would be Heckler versus Cheney, where the court said that judicial review of prosecutorial or enforcement discretion of an agency is, quote, presumptively unreviewable. Then we have the APA with Section 704, only discrete actions can be challenged, not broader policies. And then the third point is with regard to the evidence that is necessary under the APA substantive review standard of 706-2A, let's say pretext. Department of Commerce versus New York, immigration case, by the way. The court did not enunciate what specifically was pretextual about the government's proffering, what was contained in the administrative records. We don't have that. So my question to you is, if this is a problem, and I think it is generally a problem that needs to be engaged upon, what would be the basis to rebut the presumption of non-reviewability under Heckler? And what evidence would be necessary to show pretext or some other basis to find arbitrariness or capriciousness?
You want to go first?
I mean, I'd say, maybe if the agency explicitly said, you know, we're not enforcing the statute, not because of resources or priorities or decision to focus on the most compelling cases, but because we don't like the statute in some way, that might be, you know, something that kind of gets around the problem of discretion.
Right, I agree, Sean. It's where do you draw the line between, I think, as Ryan formulated it, individualized prosecutorial discretions, either civil or criminal, and then more a general statement of policy or a final rule or applicability. And I think it's tough because you take immigration or environmental law, there's always going to be some enforcement, but it may be suboptimal from a policy perspective. The one example I'll give is the glider truck kit rule from the DC Circuit, where I'm not going to say who I think did this, but in the last administration's EPA, they literally issued a policy that said, we don't care if you have glider kit trucks, and for those who don't know, those are older, more emitting trucks, and there were some statutory issues, and they just said, we're not going to do anything with this. That was challenged and actually stayed in the DC Circuit. I don't know if you did, if you did that, Sean. I mean, I think it was in fact stayed like the same day it was filed. So that's an example, but that's really, I think it's rare. I've tried to, it's difficult.
Is there a separate mic in back in line there? Let's go to the mic in back, and we'll go back.
My question is, if you can use mandamus, I don't know, for instance, if you're given a magistrate commission by one administration and the next administration won't give it to you. So my question here is, we haven't brought Congress into this too much, except to say sometimes they're clear on statutes, sometimes they're not. It seems to me on immigration and environmental laws, those are the places where they've said the least specific things they could overall, because they're always given with one hand and taken away another, so maybe those aren't the best areas. But could Congress put in the statute, and we mean it, and so that they get rid of these problems of everybody bringing suit privately, that Congress has to bring it and say, you're not doing what we passed will you have standing to say you haven't?
I think it's theoretically possible under Heckler versus Cheney, but I'll also say be careful what you ask for. If you look in the first term of the Obama administration, where both houses of Congress were controlled by the Democrats, you got things like Sarbanes-Oxley and some other things. So yes, Congress, I think, can clearly speak. But then the question is, do you like the consequences of what they've done? But maybe that's the point at the political process playing out.
Yeah, and I guess there are a lot of, we tend to focus on the things that get litigated and fought over, and those are a small fraction of the whole set of instructions to the federal government, and a lot of those are unproblematically implemented, or at least nobody notices when they're not.
Back to the front.
Hi, this may have come up in a different term, but I wanted to ask what role you think sort of intent analysis performed by the judiciary plays a role. I mean, we know in the criminal law context, right, the criminal's intent is something that's deeply investigated. So would you look at the agency intent or the legislature intent? Because I know there's a debate on whether you can have facial challenges to laws or it has to be as applied, scalia has a view. I know that in the immigration ban case, one justice at least wrote an opinion that said this should totally be rejected because things he said in the campaign trail proves that he has this First Amendment violating hatred towards a particular religion. So is intent analysis the right way to look at this, or what courts could be able to police when people do these categorical things or try to cancel laws that are on the books or unenforce them?
So I'm not a big fan of courts trying to peer into the minds of, agency officials or legislators or politicians generally. But I think what I'm trying to drive at is that, just normal APA review does involve, on the part of courts, some evaluation and assessment of the reasons that the agency is providing for the things that it's doing. And it's a completely acceptable thing for courts to, address those, consider those reasons. So, the Migrant Protection Protocol program, for instance, that I think might be a good example of what I'm driving at. This was a program, it was just argued in the Supreme Court, but it was a program that was created by the Trump administration, and on day one of the Biden administration, they canceled the program. They canceled the authority. They offer no reason for it at all. And then, right, and so, and it did that across all kinds of immigration policies, just canceled them. Day one, without an explanation, and then are shocked that the deluge arrives, and then they turn and use the deluge as a reason for why they can't continue to enforce the immigration laws, right? The whole thing's absurd. But it all started with unreasoned agency decision-making at the very beginning. And all I'm suggesting is that courts, certainly like they were willing to do with the Trump administration, should apply the same standards. If we're going to go down this road, let's go down the road and make sure that the executive branch is faithfully enforcing the laws that the people's representatives have enacted.
Next.
Thank you. I appreciated the very vigorous defense of Heckler versus Cheney and the principle of the executive really should have this discretion. And in thinking about that in terms of Chevron, is Chevron really a great instrument in order to, rein in agencies when we're, step two has become kind of the big thing, very few step one cases, lots of very vague laws. Step two decisions often don't result in a lot of precedent. They're very fact specific. They can involve the courts in very, very complex regulatory subjects that the courts maybe have very little expertise, such as in Chevron itself. It's a very complex, very intricate regulatory dispute. So in thinking about the role of Chevron, maybe Chevron, we should use things like the non-delegation doctrine or forcing Congress to write tighter statutes instead of using Chevron somehow.
Let me jump in, and I'm sure Ryan and others probably want to talk about non-delegation as well, but I think that Chevron doctrine is too much of a blunt instrument. As I said, very good reasons for the doctrine. It's a sound concept in general. and I wouldn't throw it out entirely, but it needs to be, and it is being, I think, rethought, ultimately by the Supreme Court. They created it. And the question is, you got prong one, you got prong two, and on prong one, it's not just, does this word have only one clear meaning that's unavoidable? That's way too narrow an aperture for prong one. I think it's a broader, it should be a broader analysis looking at all the tools of statutory construction and the entire statutory scheme at play to determine if it's clear to the court that Congress intended this, or Congress meant and understood this would go this way or this way, both positive or negative. Was this authorized? Was this not authorized? And then on the reasonableness prong two, if you've got ambiguity and there's multiple reasonable interpretations, reasonableness ought to take into account, is this a field that Congress contemplated the statutory regime would go in? I mean, the agency could enter into this new field over here. Because that's what we see happening. Agencies exploit Chevron deference to go into entirely new fields that I think Congress, when it enacted the statute, did not contemplate at the time. There may not be a clear answer because the field didn't even exist then, perhaps, but Congress didn't contemplate it. And I mean, I just think, for example, I violently disagree with Justice Gorsuch's opinion in the Bostock case, interpreting, the term sex in the statute. I mean, it has something to do with sex, yes, but we all know Congress didn't contemplate what was at issue in Bostock when it forbid sex discrimination. So comes up a lot more in the regulatory context, like fuel economy, but I don't know, Ryan, if you want to talk about non-delegation, he mentioned that too.
Well, I know, so like the major questions doctrine, for instance, has been discussed a little bit, and I'm all for it, but I guess, but I think that that's just, that's the court's refusal to grapple with the non-delegation doctrine, because that's really what's at play here. The problem is, Congress enacting laws that don't provide, specific guidance to the executive branch on how to carry the laws out. And in the absence of that, the executive branch is out there just doing whatever it wants to do. And, I think we should put a stop to that. And I think that the court should just get down to brass tacks and put teeth back into the non-delegation doctrine and not fool around with this sort of major question doctrine. I mean, who's to say what's a major question or not? I mean, the question is Congress providing specific enough guidance and direction to the executive branch? And if it's not, then it shouldn't be permitted.
We should have time for two more questions, so let's start.
As quickly as I can. I actually have 3 issues, but I'm confident the panel can handle them quite efficiently. My first issue has to do with elections as the salvation for implementation or non-implementation of policy. My second issue has to do with the unelected politicians and advocates within executive agencies. And my third issue is a variation of, it reflects the same issues in immigration. For the first one, very quickly, I had the privilege of serving as an attorney on the Hill with the committee with jurisdiction over both infrastructure, Department of Transportation, as well as EPA. In the course of my experience on the Hill, we were so frustrated with executive branch overreach that I went to the Environmental Protection Agency as an executive under the Democratic administration and a Republican administration. And in each instance, we were trying to bring some sense to implementing the statutes. And we both were frustrated with unelected official overreach and blatantly ignoring the political dictates. I'm talking about Democrats and Republicans, and this was in a time when it was not as polarized as it is now between the parties. My third privilege was to practice law because of executive branch overreach. I had clients that were normal human beings and very large corporations. I am most proud of I was not compensated by the White House, but I had the opportunity to work with Boyd and Gray, David Rifkin, and John Schmitz. And I worked with them because I learned that the Environmental Protection Agency had told the White House that they would indeed go forward with certain aspects of the Clean Air Act legislation and would go forward with the White House's policy. And I have both documents. After that consultation, White House thought it was taken care of. EPA went up to the Hill and advocated their original position. My role in that regard was to have a visit with David, and then a visit with John, and then a visit.
We're running a little short on time. Could we get a question?
And I'll wrap it up in 2.5 seconds. So I made my first 2 points. Here's my third in regard to immigration. I don't think you'll ever see it in the Washington Post or the New York Times, but if you choose to go on YouTube, you will see State of the Union addresses by Bill Clinton and Obama stating that our borders are unsecured and are the most dangerous aspect that we have that needs to be addressed immediately. It was not an issue of partisan party, if you would, issues on immigration.
Thank you.
Any comments?
Thank you for your comments.
One more question. We have just enough time for it.
And I promise to be quick. One of the things I think that I've noticed in practice, because I predominantly practice in administrative law, is that the government is now pushing in a lot of its briefing a collapsing of Chevron step 1 and 2, and they just jump to reasonableness review. District courts seem somewhat inclined to look at it and say, it's reasonable. What can practitioners be doing to really bring back the analysis for courts to say you need to engage in step 1? Certainly Chevron note 9, which is the basis of Kaiser, is still very important. How do we get courts to engage with that?
I guess, if I may.
Please.
I mean, in my area, there's a sense that you better contend with the text, and lower courts still apply Chevron, but people in the Supreme Court don't. It's basically perceived as sub silentio, if not overruled, relegated to the back room. And so you may practice in a very different area where courts are kind of highly deferential from the get-go, but in the administrative law areas I practice in, you almost don't make the step 2 argument. You jump to explaining why the text, a best meaning argument. And I'll just say, I don't know what's going to happen even this term with the court with Chevron, but I think we can at a minimum expect something like happened with agency interpretations of regulations under Kaiser, a kind of tightening and instructions that we need to make sure that this is an area where Chevron should apply. We need to engage with the text every time instead of doing what you suggested, kind of jumping to, well, does this sound generally reasonable? But anyway, I don't know if you want to share what area you're practicing and where there's this greater instinctive deference.
No, I mean, I think you see it in some of the independent agencies in particular, and it might just be as a byproduct that their statutes are
Right.
a little bit more open on the edges.
Right. Interesting.
I've been asked to announce that lunch will immediately follow the panel in the stateroom. Please join me in thanking our panelists for an excellent presentation.